person's first appearance will be in front of a district judge. The district judge will inform that person of what his or her rights are, what the charges are, and as a general rule will set the bond for that person, which means the amount of money or property that must be posted before that person can be released. And if the person is charged with a felony, he has the right to what is called a preliminary hearing. And this is a hearing where facts are presented by the Commonwealth of Kentucky, and there must be sufficient facts to convince the district judge, not a jury, but the district judge, that there is probable cause that a crime has been committed. And by probable cause, it means that more likely than not, a crime was committed, and committed by the person who is charged. If the district judge believes that probable cause has been shown, then he refers that matter to the grand jury. And then the grand jury will consider the matter and determine whether or not felony charges should be brought against that person. But that is what a preliminary hearing is. It takes place in district court, and it is a judge that makes that decision, so there is no jury. Civil cases are also heard in district court. And a civil case is where one party files a lawsuit against another party. And I suppose that the best example of a civil matter is like an automobile accident, where one party runs into another party, and let's just say that there's only property damage involved. If the amount of money involved is under $4,000, then that matter must be tried in district court. District court is called a court of limited jurisdiction, and it means that those matters which come before it by statute, they are limited, and the limit in civil matters is $4,000. As I have explained, the limit in criminal matters is that anything other than felonies come before district court. Even in a civil case, there is the right to a trial by a jury, and as long as the amount of money involved is $4,000 or less, then that is tried in district court. Now, there's another arm, if you will, of district court that truly is people's court, and that is small claims court. If the amount of money in controversy is $1,500 or less, then the parties have the right to be heard in small claims court. In small claims court, the judge listens to the proof. There is no jury. And as a general rule in small claims court, there are no attorneys, no lawyers involved. Instead, the parties present their respective cases, and after the judge has heard the proof on both sides, then he or she will make a decision as to which party will win and which party will lose. The rules of evidence are more relaxed in small claims court as opposed to the regular division of district court, and certainly as opposed to matters which are tried in circuit court. The other type of matters that are heard in district court are guardianship and conservatorship, where a person is not able to handle his or her own affairs, and someone else has to be appointed to handle those affairs. And what happens is that those people would go before a district judge. It has to be shown to the district judge that a person cannot handle his or her own affairs, either because of age, some other infirmity or disability, and then a person is appointed to handle the affairs of another. And then the final matter that is heard in district court are mental commitments, either voluntary or involuntary hospitalization, where it has been determined by doctors that a person is no longer mentally capable of handling himself or herself and is a danger to himself, herself, or to others, then there's the possibility of having that person committed to a state hospital. And in those instances, there is the right to a trial by jury. There's the right to an appointment of a lawyer if the person involved does not have a lawyer, and those matters can be heard either before a judge or before a jury, but as a general rule, they are heard before a jury, and the jury determines whether or not someone should be committed to a hospital. The next court we're going to talk about is circuit court. As I began telling you that I was the circuit judge in the 15th Judicial Circuit, the 15th Judicial Circuit is the same as the district, and that is it includes 3 counties of Carroll County, Owen County, and Grant County. Circuit court is referred to as a court of general jurisdiction. I told you that district court was a court of limited jurisdiction in that it is specified what matters go before the district court. Anything not included in those categories automatically goes into circuit court. So it is a court of general jurisdiction. All matters which are left over, all matters which cannot be addressed in district court, are handled in circuit court. The types of cases that are heard in circuit court: civil cases. I told you that $4,000 was the limit for district court if it's $4,000 or under. Therefore, any civil claim where one party has brought suit against another party and the alleged damages exceed $4,000, then that matter must be tried in circuit court. There is the right to a trial by jury on those matters, and in civil cases, 9 of the 12 jurors must agree before a verdict can be returned, making an award to a party. Felonies. I told you about the preliminary hearings that can take place in district court, but the actual trial of someone who is charged with a felony must take place before a circuit judge in circuit court. And again, a felony is defined as a crime, the punishment for which is confinement in prison and or fines. But if there's any possibility of confinement in prison, then that by definition is a felony and must be tried in circuit court. And before a person can be charged with a felony, his or her case must have been submitted to a grand jury. A grand jury is a group of citizens from that particular county that usually convenes at least once a month. Cases are submitted to the grand jury for a determination as to whether or not it is more likely than not that a crime has been committed. The grand jury will hear people who have information about that alleged criminal activity, and if at the conclusion of the evidence that is submitted, if at least 9 of those 12 jurors believe that a crime has been committed, more likely than not a crime has been committed, then they will return what is called an indictment. An indictment does not mean that a person is guilty. It is just a formal charge saying that the person will have to come to court to address those charges. When a person has been indicted, he or she is then either arrested or served with a summons to appear in court. When that person appears in court, then the rights are explained to that person, telling him or her that there is the right to a trial, including the right to a trial by a jury, that if the person cannot afford a lawyer is appointed for them free, that they are presumed innocent. It must take proof beyond a reasonable doubt before that person can be found guilty. And at that point, if the person does plead guilty, the matter is ultimately set for trial. And most cases that are tried in circuit court alleging the commission of a felony are tried before a jury. A person has the right to give up that right to a jury trial, but in 95% of the cases where a person is charged with a felony, there is a jury trial involved. And with those jury trials, there are always 12 people on the jury. All 12 must agree unanimously that the person is guilty beyond a reasonable doubt before he or she can be found guilty. All felonies are tried in circuit court, and as I've said, a felony is an offense where a person can be required to go to prison if convicted, but it also includes capital offenses. And a capital offense just means that if the crime charged is one for which there is the possibility of the death penalty, then that is designated as a capital offense, and that certainly must be tried in circuit court, and there is the right to a trial by a jury. Divorce cases are tried in circuit court. Anytime a person files for divorce, the matters of division of property, child support, child custody, child visitation, all of those matters are heard before the circuit court judge or someone appointed by the judge to hear those matters. The circuit judge has the right to appoint what is called a domestic relations commissioner, and that domestic relations commissioner can hear those facts which have been presented by the parties, make recommendations to the circuit judge, and then the circuit judge will ultimately enter the divorce decree and determine the matters of child support, child custody, and child visitation. Divorce actions are heard only before the judge, and there is no right to a jury trial in divorce actions. Adoptions are heard in circuit court. Should it be a private adoption or an adoption through a state agency? Anytime a person is to be adopted, that must be done with approval of